tenant screening, criminal history, and assistance animals, applying fair housing principles during the rental process. Throughout this class, we've discussed how fair housing applies when marketing properties, communicating with consumers, and providing professional services. Fair housing responsibilities also extend to the rental application process. For landlords, property managers, and real estate professionals, one of the most common questions is, how do we screen applicants fairly while still protecting the property and other residents? The answer is to develop consistent, objective screening criteria that are applied equally to every applicant. Criminal history screening. For many years, landlords routinely rejected applicants simply because they had a criminal record. However, HUD has cautioned housing providers against blanket policies that automatically deny housing based solely on an arrest record or criminal history. In 2016, HUD issued guidance explaining that broad criminal history policies may violate the Fair Housing Act if they create a discriminatory effect on protected classes without serving a legitimate, non-discriminatory business purpose. This does not mean housing providers must accept every applicant with a criminal history. Instead, screening policies should evaluate each applicant individually. Factors that may be considered include the nature and severity of the offense, how much time has passed since the conviction, whether the offense presents a legitimate risk to persons or property, whether the policy is applied consistently to every applicant. For example, an applicant convicted of a recent violent felony may present a legitimate safety concern. Conversely, automatically rejecting every applicant with any criminal conviction, regardless of its age or severity, may expose a housing provider to fair housing challenges if the policy has an unjustified discriminatory effect. Consistency is critical. Arrests are not convictions. Another important distinction is the difference between an arrest and a conviction. An arrest alone does not establish that someone committed a crime. Because of this, HUD advises housing providers to avoid making housing decisions based solely upon arrest records. Instead, decisions should be based upon legitimate, documented factors that relate to resident safety or property protection. Reasonable accommodations and assistance animals. Another area that frequently generates fair housing questions involves assistance animals. Many housing providers maintain no pets policies. However, an assistance animal is not considered a pet under the Fair Housing Act. Instead, it may be a reasonable accommodation for a person with a disability. Assistance animals may include service animals as well as other animals that provide disability-related assistance or emotional support. Because they are not pets, pet fees, pet deposits, breed restrictions, and weight limits generally cannot be applied to a qualifying assistance animal. When can documentation be requested? Housing providers may request reliable documentation supporting the disability-related need for an assistance animal only when both the disability and the need for the animal are not readily apparent. If the disability and the disability-related need are obvious, for example, a person who is blind using a guide dog, additional documentation generally should not be requested. Housing providers should avoid requesting unnecessary medical records or detailed medical information. The goal is simply to determine whether the requested accommodation is supported under fair housing requirements. A practical example: suppose an applicant applies for a rental property that has a no pets policy. The applicant explains they have an emotional support animal related to a disability that is not readily apparent. The housing provider may request reliable documentation confirming the disability-related need for the animal. If appropriate documentation is provided, the request should generally be treated as a request for a reasonable accommodation, not as an exception to a pet policy. Develop consistent policies. One of the most effective risk management tools for landlords and property managers is maintaining written screening policies. Those policies should clearly explain financial qualification standards, occupancy requirements, criminal history review procedures, reasonable accommodation procedures, application requirements. Most importantly, every applicant should be evaluated using the same objective standards. Consistency helps reduce fair housing risk while protecting both consumers and housing providers. When questions arise about criminal history screening or assistance animals, avoid making assumptions. HUD guidance continues to evolve, and fair housing decisions often depend on the specific facts of each situation. If you're uncertain, consult your designated broker or qualified legal counsel before denying an application. Online discussion question: why should landlords avoid blanket policies that automatically reject applicants with criminal records? Answer: because HUD has explained that blanket policies may create a discriminatory effect on protected classes. Instead, Applicants should be evaluated individually using legitimate, objective criteria. Question: why is an assistance animal different from a pet under the Fair Housing Act? Answer: an assistance animal is considered a reasonable accommodation for a person with a disability rather than a household pet. As a result, pet policies may not apply in the same manner. Question: why is consistency important during tenant screening? Answer: applying the same objective screening standards to every applicant helps reduce discrimination claims and promotes fair housing compliance.